The gentleman from Oklahoma, Chairman Coles, recognized.
Thank you very much. I appreciate it, Mr. Chairman. And just a couple of things in response to what the three of you had to say, and I appreciate it very much. But first, a quick question to you, Mr. Burgess. What's the effect, if, assuming the repeal were to pass and actually become law, unlikely, as I think we probably all agree politically, what would be the effective date?
I think the plain language of the statute says 180 days.
Okay. So probably, I think I saw something that would be effective the end of the year. In other words, giving the Supreme Court time to make its determination. And I say that for a couple of reasons. My friend, Mr. Scott, mentioned that this is, quote, the 56th time. I think that's not exactly right. 8 of those things became law, which means they passed the Democratic Senate and were signed by the President. And those were things like repeal of the requirement for 1099s, which would have been a multi-billion-dollar exercise. That's counted as one of, quote, the repeal attempts. We've had a number of other things that collectively have saved about $62 billion. So I'd suggest we have both tried to change the law where we could find common ground, and you're quite correct, we've certainly tried to repeal it multiple times as well. The reason, and I agree very much with my friend from New Jersey's remark about not having an alternative. I've signed on to an alternative every year since it was passed. There's been multiple alternatives out there, some of them having 120, 30, 40 co-sponsors. So there hasn't been a unified Republican position, but when you're getting 140 names, you're talking about pretty serious alternatives. So there have been, but I think probably what prevented that from happening was the fact that we knew it wasn't going to get through the Senate, and we knew it wasn't going to be signed by the President. I think now you're seeing a lot of movement because of the Supreme Court, because of the sense that this thing may well financially collapse on itself, and so we better have something ready. And I would suggest that actually to both opponents and proponents. I don't say this with any kind of strong feeling as to what the Supreme Court will do. I mean, I'm not an attorney. I don't pretend to know. I think it's a pretty hard body to predict sometimes what it will do. But thinking about an alternative is prudent for both sides, wherever you are now on the Obamacare, because if the Supreme Court does come down, it will destroy the exchanges in 30-odd states in the blink of an eye, and it will undermine the finance. I'll give you a chance in just a minute, but let me finish my remarks. And to the point that my friend Mr. Burgess made, that what we shouldn't look at polls, or that was made in response to a point he made by my friend from New Jersey. Look, I think you do have to recognize this thing has just never been popular. Now, we can argue whether it should or shouldn't be. It has never been popular. You cannot find a poll that shows that it's popular, and I think we've had multiple elections where this has been a major issue in. If it were popular, my friends might well still be in the majority. It's just not popular. So, and I think that comes from 2 reasons, in my view, and this is only my view. I mean, first, the manner in which it was passed. It really wasn't passed the way a normal bill is. It didn't really get through the Senate in the way they should have. We didn't, each pass it in conference and send it back again. And I think that the manner in which the process was hijacked, essentially after a special election in Massachusetts, it would have reversed the outcome, is one of the reasons why the resistance and distaste has been so strong. The second reason, I think, is because of the manner in which it's been implemented. And this is my view. We obviously had a disastrous rollout of this thing that did not work well. But we've also had, for instance, the business mandate, which is in the law, that's been unilaterally suspended by the administration. So the idea that you get to pick and choose which part of the law you want to enforce on what kind of timeline, I think we're in court now over that issue right now. Now, again, I don't pretend to know how that court case will work out, but that tells you how strongly it is. So I don't think this is going to take a lot of time. I think the 2 sides' position is well known. I think the idea of getting an alternative ready is pretty smart, whether you're the administration and supportive of this or you're not, and you're opposed, because, again, the Supreme Court may well make this unworkable. And finally, again, I would just, ask my friends to reflect. It doesn't go away because we didn't operate in the appropriate way when we passed it, and we haven't enforced it uniformly and fairly in the implementation of it. So those are the reasons for the continuing opposition. With that, certainly give my friends a chance to respond and probably yield back after that.
Well, I know Mr. Scott wants to say something too, but I just would say this, again, I don't want to get into polling because I like to think that, as a legislator, that I'm not just, here based on whatever polling there is out there. But I did want to say, though, that, if you feel very strongly that, that somehow things are going to be different and instructing, the committees to come back with an alternative, is really something you're striving to do. And again, I know that was in the bill 4 years ago and it never happened in our committee or anybody else. Then, put some sort of deadline or reporting requirement that the committees get back to you. You mentioned the Supreme Court and when they might make a ruling. I mean, one of the things, again, a criticism is not only that this is a repeat of what happened 4 years ago, but there was never any timeline to report back. There was never any deadline. I mean, it seems to me that if you're serious about asking these committees to come up with alternatives, there should be a deadline. There should be some kind of reporting requirement, which I don't see here. I don't like to talk about process, but I guess that's, what the Rules Committee is all about. It's totally legitimate for the House to simply take up a Senate bill and pass it. I mean, I know maybe it would have been nice to have a conference, but what did the House do? They simply took up the Senate bill and passed it. I mean, that's certainly something that you can do and was done. So I think that process was totally legitimate under the Constitution. So I don't know why we're criticizing the process. I mean, I know that's always been a big thing for Dr. Burgess is the process, but the process was perfectly normal, in my opinion.
We'll just agree to disagree that that's perfectly normal because I've never seen anything like that at all, ever. And to do it in the teeth of public opinion that was overwhelmingly hostile, no wonder people feel like they were hijacked. They just do. And again, that hasn't gone away. That's not me making it up. And my town hall meetings are probably different than yours. I have no doubt my friend's accurately describing his experience. I can assure you mine are precise, very different. And I'm not going to tell you there's not some support. There is some support for, for elements of it, but not much in my part of the world. And it does get back to the process and the manner in which it's been implemented. And where I do agree with my friend, I think we should have had, and insofar as I could co-sponsor one, we did have alternatives a long time ago. I know my friend, Mr. Burgess, has probably had his name on any number of alternatives. I suspect most of my friends up here on our side have had their names on alternative. But I agree with you. I agree that we should have something ready, but I think it's probably a lot more imperative now. I think doing it previously when you knew it wasn't going to be taken up by the Senate, defeated, it wasn't going to be taken up, and it certainly wasn't going to be passed by the president. And I've been quoted as saying accurately to my friends on my side of the aisle, let's be real, you're not going to repeal something called Obamacare when a guy named Obama is president of the United States. Just not likely to happen. Okay, and so I think that's, this rifle shot approach, which has worked 8 times, is actually, the better part, is the better way to proceed, in my view. But I do think now, because of the Supreme Court, there is a chance that this might happen. So I think my friend is correct. That makes us, we are the majority in both houses, largely because of this law, in my view. So we better be ready to present an alternative post haste should that Supreme Court actually act, and we need to have done a better job on that. So I don't want to just be critical of my friend. I know my friend Mr. Scott had something he wanted to say as well.
Thank you. I just said if you're going to replace and repeal, I think it would be helpful to have the replacement available as you discuss repealing, so you know exactly what you're doing. Repeal first, and then you don't know what you're going to get. What you may get, there's one alternative that was offered in Virginia in the last election, and the Washington Post analysis of that plan was under the headline, "A healthcare plan worse than Obamacare." So if what you're going to replace it with is worse, then people might be informed of their vote going in. So it's a little out of order. On the Supreme Court, governors and state legislators, when they were considering whether they were going to set up their state exchanges, had lists of pros and cons. The idea that the tax credits would not be available was never, for their constituents, was never mentioned, to my knowledge, in any state as a reason to have a state exchange rather than a federal exchange. So, I mean, the intent, the legislative intent is absolutely clear. And so there shouldn't be any problem at all in the Supreme Court.
I'm not sure the legislative intent is clear. I seem to recall a principal architect of this plan telling us and telling multiple audiences, I suspect his testimony or his statements are going to be part of the Supreme Court case, that this was designed in a way to force the states to adopt state exchanges, that was meant to be that way. And obviously in dozens of states, that hasn't been the case. They've chosen not to do that. So I think that's the crux to the issue, but I'll leave it up to Supreme Court as to whether it's clear or not. I would suspect, and again, I don't want to get into Supreme Court prognostication, it'll probably be a split decision either way. So there's going to be pretty smart legal people on both sides of this question. There already are. Each side seems to know exactly what's going to happen. But again, my experience is going to Supreme Court is a crapshoot. But my friend knows more, has forgotten more about the law than I would ever know and about courtrooms. So to yield to my friend, Mr. Burgess.
Thank you, Mr. Cole. And just on the issue of polling and popularity, correct, you can't always be governed by polls, but you know, we used to be guided by this quaint notion that we had government with the consent of the governed. No one was asking for this. No one was. And as a consequence, it still remains desperately unpopular. I yield back.
I think that's well stated, and that to me is the key point. If it's been operating for 4 years and it's still this unpopular, then you know, I don't think it's going to suddenly magically become popular. But again, we may have a decisive point that we on our side certainly have responsibility, as both my friends on the other side have pointed out, to be ready for. And you know, I agree with my friend from New Jersey. We should have done that a long time ago, in my view. But I think both sides better think about it now, and unless, again, their crystal ball on the Supreme Court's better than mine. That yield back, Mr. Chairman.